The broadcast is now starting. All attendees are in listen-only mode.
Good afternoon, everyone. My name is Laurel Witt. I'm the staff attorney for the Colorado Municipal League, and I'd like to thank you for attending today's webinar, What Municipalities Need to Know About House Bill 181128, Protections for Consumer Data Privacy. Just a quick note before we begin, Colorado attorneys and judges who attend the entire webinar today may claim one general CLE credit. Because this webinar will be recorded and posted on our website, we will not share the course ID in the presentation. We will instead email the course ID to attendees following the webinar. Elected officials attending today will receive one university training credit. The PowerPoint presentation and the webinar recording will be posted on our website at www.cml.org under Training Materials by the end of the week. For those of you who aren't familiar with the webinar format, you should see a control panel to the right top of the screen. You have an orange arrow to the left of the panel, which will minimize the entire box. All participants will be muted for the webinar, but are encouraged to ask questions by typing them into the question box on the control panel. We will hold a Q&A near the end of the webinar, but please feel free to type questions as you think of them throughout the presentation. Okay, I'm going to do a quick introduction of each of our presenters. First up, we will have Jeremy Schubach, the Director of Legislative Relations. He has more than 13 years of lobbying experience, working directly with the Colorado legislator. Jeremy's responsibilities include working with the sections and members of the bar to develop and promote the association's legislative strategy and to direct lobbying efforts of the Colorado Bar Association. His experience at the Capitol has given him expertise in coordinating and fostering communications between an organization, legislators on both sides of the aisle, state departments, and stakeholders, resulting in successful legislation, excellent networks, and opportunities for strategic partnerships. Jeremy has helped to pass several important pieces of legislation with topics as diverse as guardianship, judicial performance, real estate transactions, trust law, and probate. He actively listens to stakeholders and constituents to find win-win solutions and create innovative strategies for solving problems. Jeremy earned his master's degree in public policy from the University of Minnesota and his bachelor's degree in elementary education from Illinois State University. Before coming to the Colorado Bar Association, Jeremy represented an association of Medicaid providers serving the needs of individuals with intellectual and developmental disabilities. Jeremy is married with 2 children, Eddie and Josie. He enjoys bicycling and reading in his free time. This year he has cycled almost 3,000 miles and is nearing the end of the Brothers Karamazov. We also have joining us in the room Aaron Goldman. Aaron is an environmental and water resources attorney in the Greeley City Attorney's Office. He graduated cum laude from the University of Florida Levin College of Law with a JD and the University of Denver College of Law with an LLM. While focusing primarily on water and environmental law in the municipal context, Aaron has also worked extensively on IT contract negotiations for municipal water providers. And finally, we have Mr. James Britt. James is the security analyst at the City of Greeley Informational Technology Department. He is an information security professional with more than 20 years' experience working in industries such as the Department of Defense and corporate cybersecurity. His experience includes personnel and physical security, network security, secure application development, and policy development to support cybersecurity initiatives. Mr. Britt brings to the City of Greeley an extensive background and successful implementation of risk management framework and cybersecurity framework. James is a proud veteran of the United States Air Force. All right, I'm going to go ahead and hand it over to Jeremy.
Thank you, Laurel. Appreciate the introduction. I guess lesson 1 is I need to shorten my bio by quite a bit. Secondly, it's an honor to be able to do this today for CML and to present with Jay and Aaron. So look forward to this and to the discussions. Please feel free to ask questions. We will be happy to get to whatever we can. And it really, I think, will help spark the dialogue as we go along. Want to make clear at the beginning that the views expressed herein are solely those of the authors and do not necessarily reflect the views of the Colorado Bar Association, the Greeley City Attorney's Office, or the City of Greeley IT Department. This presentation does not constitute legal advice. Speak with your attorney and IT consultant before making any decisions. And I would certainly add that legal disclaimers are important, and as your loyal lobbyist in the room, what I'm about to tell you about the history of this bill and where things stand is certainly something that continues to mature as the new Attorney General takes a look at this bill passed under the old Attorney General regime, and a lot of the answers to this question, the questions that are going to be asked, I think depend on your point of view, and therefore I think make sure that you are talking to your own attorneys or your consultants, and rather than relying on the advice here for the next 50 minutes. This is our best thinking, but it is only our best thinking. So, and without further ado, moving to the first slide, the bare bones facts. House Bill 1128 was signed into law at the end of last session. After the session ended on May 29th, it was passed in a very, very unanimous fashion. I believe that there were no votes officially recorded on the bill throughout the process. It was billed as, created as, passed as, and worked on as a data privacy bill, obviously. And being a legislator, to vote no on consumer data privacy was not going to be something politically viable heading into the election year of November. And so it was a very, very quick bill procedurally, but a very complex bill to lobby and work on with the Attorney General's office, with members of the legal community, with members of the hospital association that were deeply involved, as well as the business community, Colorado Chamber, and others. So the bill took effect on September 1st. There have been some investigations ongoing under this bill, but the Attorney General has not yet released any findings or have handed down any results, and that will become important here as I slide into a little bit more information. There is a brand new definition of personal identifiable information and personal information that we've included in these slides. The definition of governmental entity is included here, and it includes everybody. For the first time in a number of states' efforts, and certainly in Colorado, municipal governments, municipal authorities in the state were included into their own section of the bill. But rather than being a business-driven or IT-focused bill, wherein you're looking at data privacy from a Facebook perspective, or for something from a business perspective, this bill covers everybody. And relative to the unanimous actions of the legislature and the number of yes votes, there was very little compromise on it, nor was there any interest in bifurcating and having this only apply to private entities as opposed to government entities. I would add too here real quick that one of the things that the Bar Association worked on was a definition of private entity, so that, and public entity, because the definitions used in the original version of the bill were intended to cover private entity as a business and public entity as a municipality or city government or some sort of other quasi-government or government agency or function, whereas I think if you look at it from a legal standpoint, from a Colorado revised statute standpoint, public entity is certainly at the federal level means publicly traded on a stock exchange at least, or publicly owned, which would have left a gigantic hole in the definitions whereby municipalities and governments wouldn't be covered under the definition that they intended. So that was clarified, I think important here, several times in the discussion in the passage of the bill, that this does apply to pretty much entity in Colorado, any entity in Colorado. And to highlight one last piece of how this plays into the news, I think it covers anything from the Girl Scouts to children with lemonade stands, as long as they are interacting somehow with a credit agency. So if the Girl Scouts take your credit card, I think you could make an argument that they are covered by this bill, and somehow need to be taking into factoring how their data privacy is approached. The third-party service provider is anyone who has been contracted to maintain, store, or process PII on behalf of a covered entity. And I think that Aaron and Jay will get more into that. And finally, just to highlight the three components of House Bill 1128, there are all under the guise of consumer protection and data privacy, the security procedures and practices, the records destruction retention policy, and the breach investigation and notifications. And those are the three primary aspects of this bill that you need to be aware of. Real quick, and I'm coming up on sort of when I had mentally blocked to turn it over to my colleagues, I want to highlight that the Attorney General has taken the view of this bill as they were passing it, and now as they're beginning to implement it. At least Attorney General Kaufman's office and Attorney General Weiser, I don't believe, has weighed in on this particular aspect, and so I assume it still holds, is that this is intended to be a bill that is sort of a living piece of legislation, and that the definitions that are missing, or at least not as well defined as you would want in black and white law, I think in some cases for a bill of this magnitude, are intended to be somewhat vague. It is hard to define an adequate computer system. It is hard to define appropriate security measures, especially when you're talking about IT and the speed at which things develop and new processes, procedures, hardware, software are all developed in that cat and mouse game. And so what the Attorney General and the proponents of the bill really foresaw was a bill that is continually updated and defined by case law, which in short means that they are intending to investigate and begin the prosecutorial process for data breaches in order to help define what they mean by. And so, by whatever term. And so, really at the end of the day, from a political perspective, from the legislative perspective, sort of your best advice is to consult with your experts, write your best policies, think through your plan, and then pray to God that somebody else is the one that gets sued and wait for the decision to come out of them. And I mean that somewhat tongue-in-cheek, but I also mean it very sincerely, because as you're going to find out, and as you've seen from a review of this bill, it's hard to know what to do because it's not black and white. First do A, then do B, then do C. And it was designed that way. And I'll come back to that in a little bit, but I wanted to turn it over at this point. So.
All right, everyone. So we're just going to freeze here for a second on this diagram right here to really just take a second to consider really the main pieces of the law. So really what you need to have in mind is that, as Jeremy shared, the law is comprised of three main components, okay? Once you start touching and dealing with PII and PI, what Jeremy went over earlier, you really need to do three things. One, you have to maintain internal security procedures and practices to protect that sensitive info that you are now storing, on behalf of your citizens, if your vendors are storing it on behalf of your citizens, or you're doing it for the public in general. The second is that you need to have a records retention and destruction policy. In other words, when you no longer need to be holding on to this sensitive info, and you're not bound by some other statute, federal or state, to hold on to that info. So HIPAA would be a good example of an exception. You have record retention according to HIPAA. If you practice law and you're an attorney, you know very well you have to hold on to client files that may contain sensitive info for a period of time. But once you no longer generally need to hold on to that sensitive info, you need to have a written policy in place at your municipality, your special district, county, whatever the case is. You need to have a written policy that speaks to when that's going to be destroyed, when no longer needed, and how. The last is perhaps, I think some folks might view it as the most weighty, but it certainly is a serious provision of the law, and that's that things don't always go well, and at times there are hacks, there are data breaches, and under this new law, you are going to have an obligation when you suspect that the breach has occurred to investigate it, make a determination as to whether it's happened, and if that sensitive info is likely to be misused or has been misused, and if so, you have certain notification requirements that you're going to have to put out there, not only to the folks affected by the data breach, but some government regulators as well. Now, we'll get into this a little more in depth in a second, but I just want to give you a broad overview of the law. So we've been throwing around the terms personal information and personal identifying information, and in a really general sense, this is kind of a common sense slide. This isn't directly from the statute, but if you haven't already done so, I cannot encourage you enough to please download the bill itself and really pour through it. It's long. It is complicated, but it is really going to be worth your time to get a first-hand understanding from the direct text itself. So when we think of really sensitive info, we are generally thinking of common sense things: your credit card information, your social security number. Are you storing your municipal employees' driver's license numbers when you issue them parking permits? If you have a child care center at Culture Parks and Recreation, or you guys have a rec center that you operate and you're storing folks' credit card info there. If you have login accounts to your Culture Parks and Rec department and you have a username and email or a password or a passcode that folks use, security questions that folks use to log into their account, you need to consider that also. And this next slide, this is definitely something I would encourage you to study at your leisure and to really pour into. But what we did here is we tried to put a lot of effort into pictographically just depicting what these two categories of info are. And the first thing I'd really like to direct your attention to before you get into the orange circles in the Venn diagram is to first look at top on the labels. And it's a really key distinction that you need to make when interpreting and applying this law. But the legislature, for whatever reason, they have these two different terms. And as you'll see at the top of this slide, personal identifying information, PII, is the triggering definition when you're thinking of what you have to account for in your records retention and destruction policy and what you have to protect in your security procedure and practice policy. Conversely, if you look on the upper right corner, you'll see personal information, and that's the triggering definition that you need to keep in mind for your breach investigation and notification obligations. So in other words, these two categories of data are not exactly the same. They're all sensitive info, but you may have something that gets hacked that doesn't fall under the definition of PI and doesn't trigger your obligation to investigate and notify. And conversely, you may have something that's sensitive info, but it doesn't fall under the definition of personal identifying information, and so it doesn't have to be covered in your records retention and destruction policy. So now that we have that a little bit clearer, we'll go into the two circles themselves, and we'll first start on the left here with personal identifying information. Now, one key thing to keep in mind with PII that distinguishes it in large part from personal information is it doesn't have to be about a Colorado resident, okay? So this can be any person, doesn't matter whether that info is encrypted or not encrypted, and any of that info can occur in a vacuum. In other words, it doesn't have to be connected to that person's first and last name. And so what we'll see here is a few interesting things. So you'll see biometric data. So anyone who's logged on to the music app or the iPhone store on your iPhone, you may use your thumbprint to log into your account, make a transaction payment. Well, that's biometric data. That's a measurement of the human body that's used to authenticate you or your account in an online context. Any password, any passcode, your social, your driver's license. If you don't have a driver's license but you have a government-issued ID, your passport ID number, employee ID number. And that's an important one. I think a lot of municipalities out there, we have employee ID numbers floating around. And as a result of the enactment of this bill, that's now, even if you don't have the person's name on their badge, if you just have their employee ID number, that's now considered personal identifying information. Student numbers, credit card, debit, any financial transaction device. And if we go all the way now in personal information to the far right, things that are just personal information, we'll see the difference that it does have to pertain to a Colorado resident. And again, we're thinking in this context about if this information gets out, do I have to notify folks? So Colorado residents' first and last name, and it also has to be unencrypted info. So that means if there's a data breach and the info that was acquired is encrypted, you do not have an obligation to send out notifications. The only caveat in the law, however, is that if that encryption key or authentication device to unencrypt the data is also acquired, well, then you're back in the boat and you need to conduct an investigation and notify on that breach. But getting back to personal information, some unique categories that don't fall under PII but are unique to PI. You have medical information, so you think traditionally about HIPAA protected info, your health insurance ID number. You can also have a Colorado resident's password or security question and answer if it occurs with their username and email address. So in other words, that's something that will enable you to log into a Colorado resident's online account, in whatever online account that may be. And then the last, and really the kind of sanctum sanctorum, kind of the holiest of the holy of these categories of data, I guess you could say, the most protected is this middle category. So this is info that not only do you have to destroy when it's no longer needed, you have to have a written destruction policy that speaks to that category of info. You have to have security procedures in place in your organization to protect it, but also if it's compromised, you also do have to send out notifications in the event of a breach. And so that's a Colorado resident's first and last name with the following unencrypted info. So you have social, driver's license number, student ID, military ID, passport ID number. And then you also have basically anything that allows you to access someone's funds. So it's their password and security code in combination with their credit, debit, or bank account number. And we might come back to this. Laurel, do I left click to get back to this slide, or
I'll have to
you'll have to do that?
yeah.
Okay. What was that?
Let me just interject for a second too. You hit on it, but it was real quick. This applies to the data of any Colorado resident, whether or not you are storing the data in Colorado or not. So if you have an offsite server, say you're a Vail Mountain Resorts or something like that, and you keep all your credit card company or your credit card information in, I don't know, Montana, you're not exempt from this law because you have Colorado data. Assuming you have the credit card number of one Colorado citizen, you are now covered under Colorado law, even if you're a Montana company. I know, realizing talking to the CML, Colorado Municipal League, that may not be the most apropos thing to a lot of folks here, but it's important to know the scope and reach of this law. Conversely, other states now have their own version of this, where you are a Colorado municipality or a Colorado company where you have the personal information, similar personal information, the definitions aren't always the same, of somebody who resides in a separate state. You are responsible to whatever law they have about data protection too, and all 50 states have this now too. So it's a good thing to be aware of 1128, but the scope of the problem is becoming much more unmanageable until probably the federal government weighs in. So know that just because you don't have this information on site or in Colorado, as long as it's the protected information or personal identifying information of a Colorado resident, you're covered under a Colorado law, even if you're not a Colorado entity.
Sure. No, I think that's a good point. And I think maybe to bring that home for a lot of folks out there, you'll be dealing with this when you have a vendor. So let's say you have a parking vendor that helps provide you with, you don't need to have as many meter maids, you don't need to have physical meters, and you have folks who just create an online account, they log in, they pay up their meter online, they pay their tickets online, so they're sending credit card info in, their name, their address, all types of sensitive info. That vendor that you have, they're probably going to store your citizens' info off-site in a cloud storage system. So that might be Microsoft Azure, that might be Amazon World Services. And to Jeremy's point, the fact that you are contracting out for this service, and we'll see this later on in the slides, that doesn't let us off the hook as municipalities. We have an obligation to ensure that our vendors are using best practices to protect our citizens. So moving on here, let's go to the first of the three prongs of the bill, the records destruction and retention policy. So in the event that you do maintain paper or electronic documents that contain PII, you have to have a written policy for the destruction and proper disposal of this info. And the basic idea is that your policy needs to obligate you to destroy that info when it's no longer needed. The caveat or the carve out is that if there's a federal or state law that governs your organization that has a provision to the contrary, then you kind of get a pass. So in other words, if you're regulated by state or federal law and you're complying with that state or federal law on data retention and destruction policies, so HIPAA is a good example, you're automatically deemed in compliance with the data destruction and retention requirements of this bill. So a good example, and I think a lot of the folks on the line who are in the municipal clerk world will be far more familiar with this than I am, but the Colorado Municipal Records Retention Schedule is a good example of a written policy concerning the retention and destruction of sensitive info. Now keep in mind, the latest update of the CMRRS does predate this bill, and I would definitely encourage you to really, if you have, when you have the time, to get with your staff and go through the CMRRS and compare it against the Venn diagram earlier. Laurel, can you go back to that? So really compare it and see, okay, does my records retention policy, once I got permission from the state archives to use the CMRRS with whatever exceptions my municipality wanted and we passed in our resolution or our ordinance, does it really cover all the categories of info that are in this left-hand bubble? And I can tell you one thing, for example, 90.070 in the CMRRS speaks to employee records, but one of the things that it doesn't speak to in terms of destroying, it has things like it does speak to their social security number, their name, their address, records associated with employment. It doesn't have a call out specifically for their employee ID number, for example. So that's one example where you want to really go through this law and check it against your existing records retention policy. Obviously, if you don't have one, you do want to get on that stat and have a written policy speaking to the destruction of personal info. As a kind of aside, it's not written in stone, but from what I have heard, the Colorado Archives may be updating the CMRRS this summer or fall to account for the enactment of this new law of 1128, but you may not want to wait until then, and you may want to act a little bit sooner. I know there are some municipalities out there that have already updated their record retention schedule, even looking and going so far as to what constitutes secure destruction under the bill. So let's move on to the next prong, and that is your obligation to investigate and notify in the event of a security breach. So one thing to keep in mind, this really core triggering definition, a security breach is the unauthorized acquisition of unencrypted computer data, and it compromises the security, integrity, or confidentiality of personal information. So a couple key things to keep in mind there. Security breach is not defined as a hack specifically, just the unauthorized acquisition. So conceivably, if you have an employee who inadvertently emails out personal information to someone who is not authorized to have it, by virtue of sending that email, someone has, without authorization, acquired personal information. And another thing to keep in mind is that it speaks to the unauthorized acquisition of unencrypted computer data that compromises the security of personal information. So the personal information itself doesn't have to be the subject of the security breach. So in other words, if there is login or authentication credentials that don't really fall within the definition of personal information and they're acquired, but those credentials could lead someone to get into your system and access personal information, that does fall within the definition of security breach. So one thing to keep in mind also, generally a security breach, it's defined as when you have a breach on unencrypted computer data. However, if, like I mentioned earlier, encrypted data is breached, but it's also breached along with your encryption key, then you fall within the same boat. So moving on here, when you have reason to believe that that may have occurred, when you become aware that a breach may have occurred, you have an obligation to promptly conduct an investigation to the likelihood that the personal information has been or will be misused. And unless your investigation determines that that PI that was breached will not be misused and is not likely to be misused, then you really do need to proceed on to giving notice to the affected Colorado residents. That brings us to kind of the end of this prong of the bill. We're talking about security breach notifications. So you have to send out your notice within 30 days to the affected Colorado residents. Your notice needs to include date, description of the personal information involved, your contact info, so Consumer Credit Reporting Agency's contact info, the FTC's contact info, a statement that the resident can obtain fraud alerts and security freezes, and in the event that the type of info that was hacked is their password or login account, then you need to give them directions on how to change their password and security question. A few key things to keep in mind when you're looking. No one wants to be in the position to give out security breach notifications, but if more than 500 residents are affected, you also need to send a notice to the Colorado Attorney General's office. And if more than 1,000 folks are affected, you need to send a notice out to the Consumer Credit Reporting Agency, so Equifax, TransUnion, the big three. And if you have a vendor that you're using and they were storing or handling some of the personal information and they experience a hack in their system rather than someone hacking your municipality's info directly, they're obligated by law to cooperate with you. And when you're negotiating with these folks or you're dealing with these vendors, you really need to lean heavily on them and let them know that they have a direct statutory obligation to notify you of a breach, to let you know if that personal information has been misused or likely will be, and to give you all the relevant info that you need and that your CISO, your Chief Information Security Officer, if your municipality has one, all the info that you need in order to assess that breach. The one caveat to this provision of the law or the breach notification is that if you have some other state or federal law that requires you to send out breach notifications in general anyways, you can comply with that other state or federal statute. So HIPAA may have breach notification obligations also. Moving right along, and I know this is a lot of info to throw out at you guys, but we really do need to get through all this, is the security procedures that you need to have in place. And right now we're talking about internally within your own municipality. Jay, our security expert, is going to go in depth and a little bit later in the presentation into the nuts and bolts on what you specifically need to do. But as a general matter, the law requires you to, in the event that you maintain, own, or license, so if you're storing or transmitting, using a vendor to handle, if you're really touching any PII, you need to have security procedures in place that are appropriate to the size of your governmental entity and also the type of personal identifying info that you're dealing with. So obviously a lot of smaller municipalities out there, they really don't have the same manpower or resources when it comes to information security. They aren't going to be held to the same standard that a larger municipality, say, Greeley, Colorado Springs, Denver may, in terms of manpower and staff to implement security procedures. And you also want to keep in mind that the definition of PII doesn't require electronic format, so your procedures should also protect. Keep in mind, do you have a clerk up front at your rec center writing down people's credit card info on a slip of paper and running it, and then putting that info into an unlocked cabinet? Are they shredding it right after? So that's a good example on the non-electronic front. This is probably where the core of my practice as it relates to 1128 comes up, and that is how we negotiate and how we deal with vendors. And a key provision here, unless you're going to agree on your own, which I really don't think you should, but unless you agree to be responsible for that vendor's conduct and provide security procedures to that vendor to protect the personal information that they are handling, you really, really, really have to require that that vendor implement and maintain its own internal security procedures to protect that PII, that personal, that sensitive info that they're handling. Now that the measures that you need to obligate your vendor to maintain, like Jeremy said, the law is fairly vague. It does need to be reasonably calculated towards protecting the info and preventing unauthorized access, use, or disclosure. But beyond that, the law really doesn't have enough or doesn't have a lot of detail. And so what I can tell you is, in my practice when I'm negotiating with vendors, there's a few key things that I like to look for. One is consider in your municipal, your city attorney's office or county attorney's office, whether you guys want to go through the process of having a template master services agreement that speaks to IT contracts. In the IT world, we often call these SaaS or software as a service agreements, and that's really anything where you are contracting with a vendor who has a website and lets folks log into that website and create accounts. And I know, there's a lot of different examples from Unicorp payment systems, parking payment, culture parks and rec. The list goes on, but those are all software as a service contract generally. So you really want to think, should we have a master services agreement in place that has security procedures and the vendor is obligated to? Is that something that's part of our invitation to bid or our public procurement process, where we put it out front and in front so vendors know, hey, this is the standard I'm going to have to comply with? Otherwise, what you really risk is that you're going to have a patchwork of security procedures, and you're going to have some vendors that really haven't agreed to anything in writing in terms of protecting your citizens' info. And you're going to have others where you have a pretty robust contract, and you're going to try to police all these differing contracts. So some good examples of things to look at when you're negotiating these type of deals. What's happening to the data that's sending? Is it encrypted in transit and in storage? Neither, just one or both? What sort of security audits can your IT department perform on the vendor's system to see exactly how secure it is? Do they have physical environment security, so where they store the data, are there controls in place? What sort of malware do they use, or are they using regular updates to keep their systems secure? Another thing that you want to think about in the termination provision of your contract is data destruction. This doesn't get addressed nearly often enough, but oftentimes you're going to want to have in your contract a provision that really specifies what happens to this sensitive info in the event the contract is terminated or naturally expires. Who's obligated to destroy it? Do they have to provide a certificate of destruction? Things like that. Lastly, I'll also encourage folks who listen in, figure out if your vendors are insured. You should not be doing business with uninsured vendors. That should be a bottom line policy. And really, there are a lot of products out there in the insurance market that can help insulate you from liability. E&O, error and omissions policies, or data breach policies are a common product nowadays with internet companies. And if you have a vendor, which you should have them indemnify you in the event of a data breach, you don't want that to be an unfunded mandate. You don't want that to be an unfunded promise. And if you're dealing with a startup LLC or some small company, they've come in really low on the bid, you really like the service they provide, keep in mind you want them to have an insurance policy so that if things do go south, they will come to the table and be able to provide funds. So next, I am going to turn it over to Jay Britt.
All right, thank you, Aaron. Good afternoon. It's an honor to be here today. So in summary, I'm calling them 4 key sections. There's really 3 components that we've talked about. I like to break out that vendor piece, but the first one is, of course, to adopt appropriate security measure. The second is to verify vendor security procedures. 3 is to have a document destruction policy, which can also be part of your document retention policy. And 4 is a data breach notification policy. Security measures will be covered in a minute, but a great resource to review your current retention or destruction policy, or to help create one, was a review of the Colorado Municipal Records Retention Schedule, which Aaron mentioned before, which was performed by the Colorado State Archives in conjunction with a statewide review group. This retention schedule does go into some of the preferred methods of document destruction, but it does get to be a little bit thin when looking at digital data. So as a guideline, the National Institute of Standards and Technology, or NIST, provides a series of special publications directed toward computer security. And one of their guidelines is for media sanitation or media destruction. And that special publication is called 800-88. And that might be useful when reviewing or updating the policies that you have currently in place. The fourth section I mentioned, to implement a data breach notification policy, would be very beneficial in streamlining the who, what, and when to notify if a breach did occur. Items to address in that policy may include the differences between PII and just PI, any of the overlaps between the two, who gets notified, the types of notifications to send. As an example, do you do a letter? Do you do an email? Maybe both. The information the letter must contain, all three reporting agencies to contact, and any of your state officials, such as the Attorney General. Again, keep in mind this does also involve third-party service providers, and not only notifying you about a breach if something occurred on their end, but also cooperating with you in any of the investigations and any of the notification procedures. So when it comes to protection of PII, unfortunately there's kind of a gray area, since the law states, and I quote, shall implement and maintain reasonable security procedures and practices that are appropriate to the nature of the personal identifying information and the nature and size of the business and its operations. Unfortunately, this may come down to doing the best you can with the resources and budgets that you have available at the time. You know, a $10,000 budget stretched over a 2-year fiscal cycle probably won't include a security operations center with a 24/7 coverage and notification if a breach did occur or if you have a network intrusion. So instead, you may need to be looking at open source solutions or leveraging current contracts that you have with your hardware and your software vendors. A couple of thoughts pertaining to the protection of PII would be the adoption of one of the industry standard security frameworks, such as Risk Management Framework or the Cybersecurity Framework from NIST. There's also the ISO 27000 series of standards that can be reviewed and looked at. And these types of frameworks will help guide you through the discovery of your sensitive information, creating policies, requiring the protection of PII, along with the controls to actually protect it. And coupled with that would be a master service agreement, which is what Aaron mentioned also, with your third-party providers. It's something that we've really focused on here lately over the past year. And part of that MSA could be your information security requirements as an addendum. Things that it would outline would be who owns the data that they're collecting, when and how the data is destroyed, encryption of the data, and even the infrastructure and the facility security behind where their backbone is located at. And of course, what to do in the event of a security breach, because what you don't want to be doing is, in an event like that, is trying to work out with your vendor of what to do next. So you want to make sure there's clear defined roles and structure in place to help move those forward. So when it comes to mitigating steps to protect PII, probably first and foremost would be a risk assessment to determine what information you have, where it is stored, how it gets moved around. Because you really can't protect what you don't know you have. So going out there and discovering where all these pieces of information are, either hard copy or digitally, which departments have what, and discovering how it gets moved around is really key and important. You can also consider adopting a security policy or a data categorization policy. And this really helps with identifying those key pieces of information that would be classified or considered as either public information, private information, confidential, not releasable, things like that. So knowing what to protect and at what level of protection is needed is real critical and a big first step. From there, you can break things down into operational safeguards, such as this slide, such as your policies and procedures, or going into actual strategic safeguards, and that's more the nuts and bolts, such as implementing antivirus, routine patching, two-factor authentication, and encryption of your data. You can even label your media, your portable media, and organize your data into data categorizations to help your end users understand the types of data they're working with, what is public, sensitive, and private, as I previously mentioned. So unfortunately, I probably really didn't get into the big nuts and bolts about security because it's really a difficult subject to address with this law because it's so wide open.
Right.
But there are some common safeguards that are provided as guidelines by both NIST and ISO to help protect PII and sensitive information. It's always important to work with your various departments, such as IT, city attorney, your city clerks, human resources, in developing some of the security framework controls you'd like to implement. Every department in your organization, your municipality, will need buy-in to your program to understand why this law is important and the consequences if not followed. So at this point, I'd like to turn it back over to Jeremy.
No, if I could just add to that too,
please.
And I appreciate you referencing NIST guidelines and some other professional guidelines. I think that provide backbone to some policies that need to be fleshed out. I think it's important to note that in the bill, they didn't call attention to those specific policies for the reason you mentioned. Things move too fast, too quick, change too often. And one of the frequent questions I've gotten when presenting on this bill is, what's a good enough policy? And that is left open for a reason. So I wanted to highlight that NIST, 88800, I've just reversed those numbers in my head. It may provide a great set of guidelines to start from. But if you're in event of a data breach, if all you can point back to is, well, we have the 888, that's probably not going to get you off the hook. From an AG's perspective, the idea is to do a thoughtful review, a thoughtful policy. Basing something off of the 888 may be a great starting point, but have a reason for doing that. And I think that's what you highlighted in that last sentence. I just want to underscore that.
Absolutely.
Like, nothing in this bill is written so that if you just do A, B, and C, you don't ever have to worry about this again. They've purposely drafted, I think defensively and somewhat wisely, wrote a bill that doesn't provide you a standard out of, I've complied with this law. There's no easy way to comply with this law without thoughtful, long, investigative processes and procedures put into place. You can't just pick a policy off the internet, call that your internet policy, and consider yourself covered for the next 5 years. You'll be in a lot of trouble if that happens. So.
Thank you.
Yeah. Do we have questions?
Yeah,
Okay.
We actually do have a couple of questions. And for those of you listening, please feel free to type in your questions now into the question box on your right-hand control panel. So the first question I'll read out loud, and then I will answer it and also pose the second question. So the first question says, does CML have a set of sample policies or model policies?
I knew that question was coming.
I knew it was coming. So we don't. We did have, Jay mentioned a couple of good record retention documents to turn to. Can you remind us the name of those? Again, there was one with the state archivist and then one with NIST. What are those documents called again?
So, National Institute of Standards and Technology. It's the 800 series and the ISO 27000 series. NIST is free. ISO, the International Standards Organization, you got to pay a little money to be more involved with them. With my background, actually, I'm very familiar with NIST. That's what we've used in the past in certain organizations, and they provide quite a bit of detail and quite a number of guidelines for you to follow. And I'll just throw this out as a maybe a direction to point to. But the state of Colorado also follows the risk management framework, And online, they have a number of policies that you can review and look at and download. I'm not saying that that's anything that you can carbon copy and use in an organization or at your municipality, but it kind of at least kind of guides you in a direction of the type of policies and procedures that should maybe be in place.
And where can we find those? The State of Colorado website?
I would just search on that.
Okay.
I'm sorry.
Sounds
Unfortunately,
good.
I can get it to you later. Unfortunately, I don't have it handy.
great.
But it is just, if you just go to the State of Colorado IT or State of Colorado RMF framework, that should be able to bring up
Yeah, great. Thank
their
you.
URL for you.
Do you guys have any other suggested model policies?
The state archivist has, state archives has the Colorado Municipal Records Retention Schedule. There is an application process there, though. You don't just download it and use it. You need to go through their website and also go through a requested exception process. It looks like I might not have had the most current info. They may not be updating that in light of the bill, but that's all the more to the point that I made earlier about really sitting down then with the CMRRS and going through it and then going through the definitions of the statute and seeing exactly what you do and don't need to update.
And from the discussions at the end of last session with the Attorney General's office and with the proponents of the bill, they really had designed a bill that, quote, have policies and procedures that you can be proud of, right? That's hard to hang your hat on in terms of, do you have model policies and procedures? And one of the questions that was asked at the time is, will the state be issuing guidelines like Department of Local Affairs, DORA, for example, that regulate a ton of businesses and infrastructures? And the short answer to that is no. In part, and this is not intended to be as cynical as it sounds, but in part because the bill is designed to be updated and defined by case law, right? Why would you why would you provide something that is intended to be a model policy and procedure if you're trying to from one half of the government entity with the other half of the government entity, meaning the entire state, is trying to find that out through case law. So you're giving yourself an out there. So I don't think you're going to see a lot of that from the state level. My best practice would be, as other states are looking to do this, and 50 states now have some version of data privacy plus the GDPR and the California laws, right, is people are going to have to be, or private entities are going to have to start writing their own policies and procedures. And certainly they or their attorneys are going to be willing to share best practices, at least, if not model language. And so I think you'll start to see stuff roll out, but at the moment, there's really not a lot to go on.
Thanks for answering that question. We have a second question here. Is a police officer's badge number the equivalent of an employee ID number?
Yeah, I think that's a good question, and I think it can depend on your municipality. Generally, I would say no. That's very public info. That's worn directly on the badge. It's exposed to the public, and it's also, it depends on your municipality, but many municipalities will have a separate employee ID number for each and every employee that's separate and apart from the badge number. It would be an interesting circumstance if the officer's employee ID number and badge number were one and the same, but generally I would say no, given how public that info already is.
Unless you file your HR records by badge number, in which case I probably would figure that out.
Sure.
Excellent. Well, it looks like we don't have any other questions unless anybody has any last remaining questions. Do you guys have any last remaining thoughts before we conclude?
I have a question for Aaron, actually. As you were doing the presentation on negotiation with vendors, again, one of the things that's, and I'm going to speak a lot to the intent of the authors and proponents, one of the reasons that the bill does not talk in specifics, again, is because they intended for this to be tested out on a case-by-case basis. That is highlighted again in the part of the bill where they require you to have third-party vendors and third-party entities comply with 1128, be the out-of-state, foreign jurisdictions, in-state companies, vendors, or what have you. And we had a question at the bar: how do you make Google or iCloud or Google Drive comply with data privacy requirements if you're going to store your data up there? The answer to that at the time, and I think that they would stand by this today, is that we intend 1128 to be the hammer that you can use as a municipality or a business or what have you to force Google to comply. I think that's an interesting thing, and I'm wondering, based on your experience as you roll these contracts out in your master service agreement, if you are seeing that or what the success of that is.
So it sometimes yes, sometimes no, and I think that's a great question, Jeremy. I think as folks could probably predict, with smaller vendors that don't have the same negotiating power that a Google or a Microsoft or an Amazon have, yes, we do see success, or I do in my practice, at letting them know, hey, there's a state statute that authorizes my client to enact security procedures and practices. Here are our security procedures and practices, absolutely backed up by the state law. Compliance isn't optional, and if you're going to do business with us, this just has to be. I think, on the other hand, you can oftentimes run into situations with extremely large vendors who say, let me look at the text of the bill itself, and I think this is the difference, being on the practitioner side or being in the trenches rather than being in the legislature. We always want to see more specificity in a bill so that we can act accordingly and conduct ourselves accordingly, and no one really wants to be the poster child for litigation, to be out there and be the entity that creates case law. So that being said, I think there's a lot of circumstances where, and this is more a note to the attorneys, you're going to have tough conversations with your client. They may really, really like a specific vendor, and they are absolutely crazy about the price, the service offered, and the quality of the product. But if that vendor cannot comply with the law, you need to have a real, I don't want to say heart-to-heart. We're talking IT law, so it's not that serious. But you need to have a really substantive conversation with your client and let them know that it's inadvisable to do business with a vendor that simply can't comply with the law, as would be the case with a vendor that can't comply with any other law and is in breach of the law.
That's a great answer.
Yeah. Great. Well, I'd like to thank our presenters for sharing their knowledge with us today, and I'd like to thank you, our listeners, for attending. Once again, you will receive the course ID for the CLE credit by email this afternoon, and you can find the PowerPoint and the recording of this training on our website by the end of the week under Training Materials. Thank you all for joining us today. This concludes the webinar. Have a nice afternoon.
Good one.